Good evening, everyone, and welcome to this evening's conversation. My name is Scott Waugh. I'm the Executive Vice Chancellor and Provost here at UCLA. On behalf of Chancellor Jean Block, and indeed on behalf of everybody here at UCLA, I want to extend our warmest welcome to Supreme Court Justice Elena Kagan and welcome her here to UCLA. Justice Kagan, welcome to UCLA, and thank you for spending the entire day with us. Your visit has been a truly wonderful opportunity for our law community, and we're honored to have you here. UCLA Law continues to make its mark as an intellectually active community of students, scholars, researchers, and clinicians dedicated to public service. It is a relatively young school, but our alumni have gone on to prominent roles as judges, lawmakers, attorneys, executives, and advocates for justice around the world. It's been a pleasure to see the school accelerate its accomplishments, showcase and advance its commitment to public service and to deep experiential learning, and cement its reputation as one of the finest law schools in the country. Those are all fitting, because accomplishment, public service, and excellence are all qualities that also aptly describe Justice Kagan. It is UCLA's great privilege to have you with us today and tonight. We're all looking forward to the conversation between Justice Kagan and Dean Mnookin, which will take place shortly. Please join me in welcoming Dean Mnookin to the podium. Jennifer.
Thank you very
Enjoy.
much. Thank you so much, Executive Vice Chancellor Waugh, and hello, everyone, and welcome to this wonderful opportunity to talk with and to hear from Justice Kagan. I want to second everything that Vice Chancellor Waugh said in welcoming Justice Kagan to UCLA, to our law school, and to this conversation. It's such a pleasure to have you with us today. And yes, the weather really is this good every day, should you want to come back and experience it again. Now, Justice Kagan is truly somebody for whom no introduction is needed, but I will say just a few things about her background and her career, although I know many of you probably know all of these details already. She was born and raised in New York and earned degrees at Princeton, Oxford, and Harvard Law School. She then clerked for Judge Abner Mikva on the D.C. Circuit Court of Appeal, and then Justice Thurgood Marshall on the Supreme Court. She had a brief period in practice at Williams and Connolly, and then became a law professor at the University of Chicago, and then became an associate White House counsel in the Clinton administration. From there, she joined the Harvard Law School as a faculty member, and then very soon thereafter became its dean. And she was a very good dean there, too, I can say. But President Obama then named her to be the Solicitor General of the United States, the person responsible for representing the executive branch and the Department of Justice before the Supreme Court. Then in 2010, President Obama nominated her to the Supreme Court. And in the 8 years since then, Justice Kagan has truly distinguished herself as a brilliant legal mind and an excellent jurist. I'm very excited to get started with our conversation, and the way we're going to proceed is that Justice Kagan and I will talk for about 45 minutes, but then we will open it up to some of you to ask questions for a few minutes before we're through. So once again, let's give Justice Kagan a warm Bruin welcome.
Thank you very much. Thank you. Thanks to the Provost for being here with us. It's a real honor for me, and I know that you're really busy, have a lot of work to do, so you can skip out anytime you want. And thanks to Dean Mnookin for being such a terrific host over the course of the last day and evening, started yesterday, and to the UCLA community as well. This is my third event today. I might be a little bit talked out. But I got together with students this morning, and I thought the students were absolutely fabulous. And then I went to a faculty lunch and took almost as hard and good questions from the faculty, and enjoyed that very much. And now here we are. And it is. I was saying to Dean Mnookin, the comment about the weather was, I was saying, this is a beautiful day. Is it really like this all the time? And she said, you know, yeah. She told me about why it wasn't really as nice a day as many other days, in fact. So This is
LA
maybe
la-
a tad
LA
humid,
average, right?
or you know.
LA average.
Yeah.
Well, thank you. You've been so generous with your time, and it's such a wonderful thing for our community to have you here, especially.
Pleasure to be here, really.
The term starts Monday, so we
Yeah,
know
it does.
you have a lot on your plate. I'd love to begin. We have a lot of students in the room with us today, and I would love to begin by asking you what advice.
Who are the students? Raise your hand. All right.
Right.
A lot of students.
A lot of students.
Yeah.
And I would love to ask about your advice, I guess, at two different points in a law school career, both at the 1L. 1Ls are now about 6 or 7 weeks into their first semester of law school. What advice would you give them as they look ahead? And then 3Ls are obviously looking toward graduation, still a bunch of the year to go. What advice would you give them in their final year of law school or as they begin their process as junior lawyers?
Okay. Who are the first years here? How many first years? Okay, fair number. Here's the things I would say to you. I guess the first thing is I think something big and important happens in your first year of law school. And I think that this is true. I think that there are kinds of, in a way, two kinds of 1Ls. There are the first year students who come in knowing what they want. And there is the larger group of first year students, of whom I certainly was one, who come in not knowing what they want, sometimes even not knowing why they went to law school at all. I don't know about you. I went to law school for all the reasons that people nowadays tell you not to go to law school. Because I couldn't think of exactly what else to do, you know? Organic chemistry had kind of stumped me. And actually, I was what I thought I was going to do in college was I thought I was going to be a historian. And that's what I majored in college. And then I did my senior thesis, which was a fantastic experience. But I honestly decided like life in the archives was not entirely what I wanted. And so I did kind of go to law school as a little bit of keeping my options open, right? I'm sure you've heard that expression. But regardless, whether you're the first kind of law student or the second kind of law student, I actually think that there's something that happens in the first year of law school that's kind of magical if you give yourself over to it, which is this idea about learning to think like a lawyer, which, you know, I'm not sure I could define for you. I'm not sure anybody can define it. But it's something quite real about analytical thinking, about about learning how to wield arguments, about learning how to listen to arguments on different sides, about just learning how to attack legal problems. And it doesn't happen unless you kind of give yourself over to the experience. Do the reading, think about the reading, participate in class, just sort of try to figure out what this enterprise of lawyering or thinking like a lawyer is all about, and taking that really seriously, because almost all of it happens in the first year. And it's why it's so much fun to teach in the first year. After the first year, all the knowledge that you pick up will be subject matter knowledge. You'll learn this or that area of law. You'll continue to develop your skills. But nothing transformational will happen in the way your brain works and in the way you speak. Whereas in the first year, I think something transformational can happen in the way your brain works and in the way you speak. And I think a big part of the first year of law school is that. So that's the biggest picture advice I would give you. Like smaller pieces of advice I would give first years are get to know at least one professor outside of class. I mean, classes are great and all of that, but go knock on a door, go be aggressive, go, just get to know somebody as well as you've ever gotten to know a professor in your life, or better. And you'll find that people, I think, are very accessible and that they actually love when students reach out to them in this way, and I think it can be a really important part of first-year experience. Listen to the other students, because part of it is about professors and the books and all of that, but part of it is about this wonderful community of students that you have all around you. and one suspects of many different backgrounds, of many different views. And I think part of learning how to lawyer is learning how to listen to people of all kinds, with all kinds of opinions. And so get to know a wide range of people. And I think that's my advice for first years.
Great.
Did I miss anything?
That sounds like good advice to me.
All right.
How about
You're a dean, though. You want to add anything? This is your chance.
because you're here to hear what I have to say. Anything for the students about to graduate? Or not so much
Yes.
about, but getting, at least with graduation in sight?
Well, I'll talk to you a little bit. You see, now I've just already told you that you're not learning much now. So sorry about that.
There, I don't think I agree, but
That's not true. I mean, lots of, you can have really great experiences. Because I think of third year, actually, as kind of a year where you cement everything, where you take all those things that you've learned in your first couple of years and just add a little bit more to it. But I guess what I would say to you folks is how you think about a career. And this is obviously going to be different for different people, what sorts of choices you make. Hopefully that's right, that you're going to make all kinds of different choices. It would be kind of a boring law school if that were not true, which I'm sure it's not.
it's not.
Yeah. So I guess I would say two things about thinking about a career. And one is not to do things just because you think you have to do them, or just because everybody else is doing them all around you. And I think too many law students get caught up in this sort of thinking. They feel as though, well, everybody else is doing it, so it must be the kind of thing you have to do. Or alternatively, they might think, there are just certain experiences where you have to check the box and you have to go through something, even if it's not really what you want to do. And I think that that's usually wrong. I mean, for sure, sometimes if you want to get to place X, you need to do some things before it. But I think most of the time, you should do what you want to do and want to do in the moment, as opposed to something that you don't really want to do, that you're doing just because somebody has told you that it's necessary to do something you do want to do further down the line. I think usually the best careers and the careers that give people the greatest sense of meaning and fulfillment are the ones where people actually say to themselves, what do I really want to do right now? And again, don't take that for everything it's worth, because, there's something about preparation and planning. But mostly, I think law students take preparation and planning far too seriously, and don't take seriously enough the idea of doing now what's really personally fulfilling for you. And then I think the second thing I would add to that, irrespective almost if you take that piece of advice, although it kind of goes hand in hand, but be aware of the role of serendipity in legal careers. Like if you talk to a bunch of people you admire who are lawyers, a bunch of people who you think they've had really neat, good careers, and you say to them, well, how did you do that? In my experience, almost all of them say, that's a good question, I'm not really sure. And the reason that they're not really sure is because for them, it seems like a lot of the choices that they made were just sort of lucky things that fell in their path. Mm-hmm. At least that's the way it was for me, and I think that that's the way it is for a lot of people. And the thing that you have to be aware of is that when those opportunities present themselves, you have to notice them, and you have to be willing to do something that you hadn't really thought about doing. So sort of even if you're sort of, if you feel like I'm on a track, and first I'll do this, and then I'll do this, and then I'll do this, there are just, there are things that are going to happen and opportunities that you'll be presented with that don't fit on that track, that aren't part of the plan. And some people just kind of push them aside, and other people say, well, that wasn't part of the plan, but that's really a cool thing to do. And it might seem a little bit risky, it might seem a little bit out of sync with but the best careers are the careers where people notice these unexpected opportunities and actually grab onto them.
Can you give us an example of fortuitous serendipity as you look at your own story?
Yeah, I think pretty much all of it. Some people say, well, did you plan to be a judge? And the answer is certainly not. I mean, I made sort of every decision in my career in a way that I didn't quite know actually where it would take me. So when I finished clerking, I really didn't know what I wanted to do. And I went, first I went to a law firm, which I liked very much. I had a great experience there. But I went there primarily because, some people had talked to me about teaching, about coming and being a legal academic. But I really felt as though I didn't know whether I wanted to be that. And I had been in school for so long that it seemed sort of the natural thing to do. But I felt as though I couldn't make that decision without finding out about what life was like outside university settings. So I went and I was a practicing lawyer for a while. And then I found that, I could make the decision better. I came back and I was a professor. And then one day, I just gotten tenure, I picked up the phone, and one of the judges who I clerked for said, why don't you come work for me again at the White House? And I was sort of out of the blue, but it seemed really exciting. Then he called me again 2 weeks later, and he said, actually, I'm going to be leaving, so maybe you don't want to come at all. And I thought, well, this is sort of weird, because now I'm coming to this place, and he's going to leave, but I thought it still sounded kind of fun. So I went there. That ended up, I stayed there much longer than I expected to stay. I had to give up my academic appointment. I didn't quite know where that was going. In the end, I got...
It worked out okay.
It worked out okay, yeah. It totally worked out okay. But I don't know. For me, it was just sort of, I don't know where this is going, but why don't we try it for a while? And, something will open up along the way.
I'm curious about, you have had an amazing array of experiences, but you are the only justice on the current court that was not a judge before being in this role. I'm curious what experience set you especially draw on, or how that affects how you think about your work, perhaps compared to some of your fellow justices.
I would say I draw on two things. First and most obviously, I draw on my experience as Solicitor General, because the Solicitor General's job, Solicitor General is the person who is in charge of all the litigation of the United States in front of the appellate courts, and most especially in front of the Supreme Court. So you spend most of your time thinking about how to present the position of the United States to the Supreme Court, how to make arguments there, how to write briefs that will persuade judges, and so forth. And so you get to know a lot about the court, and about its docket, and about its procedures, and about the way individual justices think, the way they interact with each other. What I used to think in my first couple of years on the court, I used to think, well, this is supposed to be a new job, but I'm not really experiencing it as a new job, because for a while I've been trying to convince 9 justices of the court of various positions, and the only difference now is that I'm trying to convince 8 justices. So that's the most obvious. But I would say the other experience that I draw on a lot is my teaching, and the teaching part of teaching, not actually the scholarship part of teaching, but the teaching part of teaching. Because when I sit down and I write opinions, what I want to be able to do is to write them in such a way that not only the lawyers who are involved in the case, but a range of other people, the parties in the case, interested citizens, are able to pick up an opinion and to understand why it is that the court is reaching the decision that it reached. And when I think of how to communicate that, I think of preparing for a law school class, because for a professor in a law school class goes in, and you think, well, these are all really smart people who are going to be listening to me, but they actually don't know all that much. And sorry, but
Right.
and the challenge, the task, is to take what's often very arcane material, very complicated, abstruse sort of material, and convey it to them in a way that they will understand, and a way that will stick with them. And that's the way I use to prepare for class. It's like, well, what questions do I ask? What points do I make? So that when people walk out of the room, they'll have an understanding that they didn't have when they walked in, and that understanding is the sort of understanding that will stick with them. It's not the kind of thing that they'll forget in 15 minutes. And I write opinions in much the same way. So when I sit down to write an opinion, I sit down in much the same way that I would have sat down to prepare a class. And that's what the product is.
That's interesting. I mean, you're a wonderful writer. Your opinions are clear, but they're also punchy and witty, and it sometimes does feel like you have a broader audience in mind. Where did you learn to write? How did you become this exceptional legal writer and exceptional writer?
Well, first, thank you very much for that. Whether it's true or not is for other people to.
Right.
But my mother would be glad to hear you say that, because my mother was my first writing teacher. She was a 5th and 6th grade teacher, and she took writing extremely seriously, her students and her children's. And so I really do think I was lucky enough to have a parent who couldn't really stop being a teacher when she was home, and I learned a ton about writing from her. The other person, again, I would say 2 people before I got to law school. The other person was in college, and it was that same senior thesis that made me discover that I was not going to be a historian. But I had a professor my advisor for that thesis, who literally went over it with a fine-tooth comb multiple times. And it was the first experience I had had in years of somebody really just sitting down and saying, what's working about this sentence? How could it be better? What's working about this paragraph? How could it be better? What's working about this argument? And what isn't working in all those cases? How could it be better? And I think you are blessed to at some point have a teacher like that along the way.
Now, those were both experiences before law school. Does that mean once you get to law school?
No, well, first off, if you haven't had those, go find somebody in law school who will give it to you. But, it could be even a friend. It could be a coworker once you get out of law school. I was actually saying to the group of students I talked to this morning that for me, one of the things that was really helpful to me on the court was when I got on the court, I had a clerk in my very first year of judging who was a fantastic editor. Fantastic. And even now, 8 years later, I can look at something that I've written and I can think, what would she say about this piece of prose? And how would she change it? And what would she think was wrong with it? So I think, trying to connect with people who are really good writers themselves, and whether it's coworkers or co-students or or teachers, and just trying to be a sponge as to what they can tell you about the craft of writing, and particularly about the craft of legal writing, which depends on the craft of writing, but adds some more things. And I think it's really important. I mean, there are lots of different kinds of lawyers in the world, and lots of skills that some lawyers need and other lawyers don't. And there are occasional jobs, I think, in the legal profession where it just doesn't matter all that much if you write well. But I think in most jobs in the legal profession,
really does.
writing is kind of the coin of the realm. And so it's something that's really important to work on when you're young and when you're older. I learn from my colleagues. Some of my colleagues are fantastic writers. One of my colleagues, the Chief Justice, is this sort of like perfectly classically beautiful writer, cannot write an inelegant sentence. And so, I learned from reading his prose.
That's great. So it's not too late for any of us. That's good. I'd love to ask you, I want to turn a little bit to the court and some of the dynamics on the court. And in particular, you had a relatively extensive period with just 8 justices, the better part of 2 terms, really. And I'm interested in what effects that had on the dynamics of the court, or how you thought about the process, whether it changed anything, and whether anything emerges from that.
Yeah, so it was a real change. Obviously, when Justice Scalia passed away, it was an enormous adjustment for the court. I think when any justice leaves, that's true, but Justice Scalia had been there for so long, and he had such a towering intellect and personality both, so that that absence was just palpable. So part of the 8-person court was kind of getting used to his not being there, but then the other part of the 8-person court was trying to figure out how to run this institution with an even number of people. I mean, there's a reason why most appellate courts do not have an even number of people, and that is because nobody knows what to do when you have a tie.
Right.
And there are some number of cases, I think it's much fewer than most people think, but there are some number of cases where we are divided, and when we had an 8-person court, evenly divided. But none of us wanted for the court to look as though the court couldn't do its job. I think we all felt as though the country needed to feel as though the court was a functioning institution, whatever was happening outside. And so we all worked very hard to keep to a minimum the number of 4-4 ties. I mean, if you're really stuck, you can just say, we've tied, sorry, and in that case, the decision below was affirmed by an equally divided court. But we tried super hard not to do that. And what that meant, I mean, it obviously meant it meant reaching consensus in places where we at first didn't have consensus. Sometimes that can happen just by continuing to talk about the same question. More often, I think it happens, and I think if you think about decision-making and how to reach consensus, I mean, often the key is to adjust the frame a little bit, we're fighting over this big thing, but within that big thing, there are smaller things that we can actually agree on. And so we should refocus the case so it focuses on those smaller things, or one of those smaller things that we can reach consensus on. Rather than just keep on bashing each other about what we disagree about, finding a place where we could agree, even if that meant that we didn't decide everything, that we didn't decide the whole problem. And sometimes there was a sort of artificiality about that. I mean, occasionally, I think we announced decisions that people think, well, it's very nice that you agree on this, but nobody really disagreed with this.
Right.
It wasn't really what the case was about. And everybody still needs to know what the answer to that big question is. I could say that and you could laugh, but I think that was actually the less common thing. That more commonly, we felt, well, we haven't done everything, but we've done something of importance that will help people, that will help litigants, that will help the rest of government, know what the rules are. And that we've done it in a way that shows that we're not as divided as people thought we were. And that was very important. It was very important in terms of actually answering some questions, and it was very important in terms of making clear to people that we were a functioning institution which was not as deeply divided as they might have thought.
Do the lessons learned in that moment out of prudential necessity have any ongoing relevance when you're no longer just state justices?
Yeah, well, I hope it does. I think that the jury is still out on this. And I think it's harder, right? Because, as you say, we had to do that. With 9 justices, as we were last year, there was less need. There was no need. I mean, but you would get to the end of the voting and discussion process, and you would have a vote, and it would be clear whether that there was a winner and a loser. But I do think going forward, thinking about that process and the virtues of that process, essentially the virtues of consensus building, especially perhaps in a time of acrimony and partisanship in the country at large, makes a lot of sense. And to force yourself to say, well, look, we could decide this case 5-4, but that would make clear that we are deeply divided on some big fundamental issue. And maybe the wiser course is to see if we can do something useful where we're not so deeply divided, where we suggest to people that we're finding a broader consensus. Now, why is that important? I mean, it's important because the court's strength as an institution of American governance depends on people on it having a certain kind of legitimacy, on people believing that it is not simply an extension of politics, its decision making has a kind of integrity to it that is something different from what you find in the political branches. And if people don't believe that, they have no reason to accept what the court does. And that would be a great shame, that one of the beauties of our system of governance is that for many, many, many years, with a few exceptions, but incredibly few, really, even when the court has decided some really hotly contested issues on which people feel strongly, that the court's decisions have been accepted, and that nobody said, look, why should I pay attention to that? So I think that the court has a real interest in preserving its institutional legitimacy, and more important, I think the country has a very serious interest in the courts finding a way to operate that does that. And I think to the extent that you can build broad consensus, rather than having everything look as though it's divided along similar lines as people can see in the political branches of government, that's a very healthy thing.
But so how do you think about when to either narrow the frame or compromise versus when to dissent and
Right.
dissent in a louder voice? I mean, how do you think about those trade-offs?
Well, these are hard calls for judges. I mean, there are some things that it's impossible for people to compromise on, and impossible to do anything other than dissent with respect to. And I've certainly been in a position where it's like, I can't go along, and I can't go along even if you make a few adjustments, because we're disagreeing on something more fundamental that we can't figure out how to bridge. And sometimes that's, you have to do that, and you have to, maybe you're speaking to a next generation. You're surely not telling everybody ignore this decision, but you are saying, I hope in the future people will recognize the error of this decision and will reverse it. And in some of the greatest moments in American legal history have come from dissents that really changed the world, not immediately, but in the long term. And sometimes that's absolutely crucial to the way our legal system progresses. But it's not crucial all the time. And I think one should not make, not every decision has such, is one of the ones that you have to stand your ground on. That in judicial life, just as I think in political life, just as I think in the life of an institution like a university, it can't do its best work unless people are willing to listen to each other and willing to be persuaded by each other and willing to find common ground with each other.
I think you just answered one of my questions, which when you were dean at Harvard, you took a fractious school and helped it generate consensus. It sounds like I was going to ask what advice you would have for me, but I think I might just have heard it. Anything to add on that score?
No, I think you're doing fine, Mnookin. I think I wouldn't presume.
I'm curious, when you went from 8 justices to 9 with the addition of Justice Gorsuch, it also meant you were no longer the junior justice.
Yeah.
So I'm curious if you can tell us.
I was the junior justice for a while.
Right.
Yeah.
You were.
Yeah. I mean, a lot of justices aren't, right? If you think about the court, sometimes there's a lot of turnover. People are junior justice for only a year or two. But
you had an extensive period.
Yeah.
What does that entail?
Hazing, mostly.
The cafeteria committee? What
else?
Yeah.
So, in a way, it doesn't, as to the important things, actually, I'm not sure it entails all that much. I mean, I think the court right away, you get on and people respect that you are a justice of the Supreme Court and you have the same vote and you have the same voice around the table when we make decisions as everybody else does. Although it is true that you speak last, which has certain consequences in terms of how you convey your views to your colleagues. So you can ask me about that for in a moment, because that's actually, I think, pretty interesting. Yeah. But the hazing part of it is you get on and you kind of think, sort of, at least I thought, I'll just, make this about me. I thought, now I'm pretty hot stuff, I'm a Supreme Court justice.
You are.
Yeah.
We agree.
And the first thing that happened to me was that was that I was put on the cafeteria committee. That basically happened the first day. And you wonder what the cafeteria committee is. And literally, it meant that every month I went to this meeting, and it would be, well, what happened to the good recipes for the chocolate chip cookies? Which I was kind of accustomed to as a dean.
A dean,
yeah,
right, exactly.
But you can imagine how some justices find this a little bit like, really? And it's actually, nobody really thinks that you have expertise on the chocolate chip cookies, but it's really a way for your colleagues to express disappointment in the food. So,
it sounds more like deaning. I understand.
Yeah, you'll go up to lunch. We have lunch together, just the justices, every time we have argument and every time we have conference. You go up to lunch and people will start eating their lunch and somebody will say, the soup is too salty. And look at you, And then another person will say, I don't think the suit was salty enough. And look at you again, you know? So there was that. The other particular jobs of the junior justice are you take notes in conference. When we make decisions, it is just the 9 of us in the room. There is nobody to mark down what we're doing. There's nobody from the clerk's office who, in the end, is going to have to announce our decisions to the world. So somebody has to take notes, and the junior justice does that. Keeps track of all the votes and conveys them to everybody who needs to know about it around the building. And the other thing that the junior justice has to do in that conference is open the door. And you might think, why do you need the door open? The whole idea is to close the door, and then you can talk about all these confidential things that you need to talk about. But it turns out that justices are forgetful human beings, so somebody will forget her glasses, or somebody will forget, his cup of coffee, or somebody will decide that, no, he has the wrong file, and will call their chambers from the conference room and say, bring me my glasses or bring me my cup of coffee. And then it's a very, it's like 2 doors, just so nobody could listen at one of them or something. And somebody will knock on one, and then you'll open the other and get it, whatever it is, and bring it to the justice. And really only the junior justice can do this activity. So there was, about 3 years ago, I did something to my foot, and I was walking around on one of those big boots, which made kind of, walking was sort of clunking.
Not easy, right.
And even then, the door would not. And everybody would stare at me, So when Justice Gorsuch came onto the court, it became a little bit of a court joke, because every time there would be a knock at the door, I would jump.
You'd had years of training.
Yeah.
Right.
And he would go, sit down, Elena, it's my turn to get the door. So
I do want to come back to that point about speaking last.
Yeah.
I mean, a lot of psychologists would say that first or last is more powerful than somewhere in the middle.
Very
Did you
interesting
like that?
point. Yes, I actually miss speaking last. I think I'd rather speak first or second, maybe, or maybe even third, but, certainly ninth is a lot better than 8th or 7th or 6th.
Right. I can see that.
But the way we vote actually does affect, a lot of people wonder why it is that we honestly talk so much at argument and don't allow the lawyers to talk all that much. I mean, I think if you come to a Supreme Court argument, what you'll find is that the lawyers can barely get a word in edgewise. And that a lot of the quote-unquote questions that we ask are declarative sentences
Yes.
that somehow will find a way to put a question mark at the end, but not really. And I think some people look at that and they say, well, why are they doing that? This is the only opportunity that they have to hear from the lawyers, and it's kind of rude. And I think that that's actually not so. I think it's a good thing that we do, at least within the confines of our system. Because we've already heard from the lawyers. We've all read the briefs. We're a very well-prepared court. Everybody takes the decision-making process really seriously, and everybody's read all the arguments that there are to be made. And the function of oral argument sometimes is to test certain points that the lawyers make and to really figure out what the lawyer thinks about something. But at least as often, and probably much more often, the function of oral argument is to talk to each other, because we don't talk with each other about a case before we go into oral arguments. So the argument is the first time that we're actually conversing about a case. And after argument, what will happen is that we'll wait 2 or 3 days, and then we'll go into conference, and then we'll start discussing, but we start voting very quickly. The way conference works is that it goes around the table from the Chief Justice, who always starts the discussion, by order of seniority through to the Junior Justice. And what each person will do is to say, here's what I think about the issues in this case, and so I vote to reverse or affirm. or vacate and remand, whatever the case may be. And so if you're coming last, now, sometimes after everybody's gone around once, and there's a rule that nobody can speak twice until everybody's spoken once, which is a good rule if you're the last person. And then, conversation will often break out, and we'll respond to each other's points and so forth. But it just is hard. It's harder to persuade somebody of a view when that person has already announced a different view, right? That's right. When somebody says, I vote to reverse, and you think that the right answer is to affirm, occasionally it happens that you can convince people, but it's a heavy lift. It's a heavy lift. Yeah. So the way to avoid that is actually to make the arguments before people start voting, and the only place to make the arguments in the way we do things before people start voting is at oral argument. So the way I think to understand what we do at oral argument is to understand that it's the first step of our own decision-making process, where we're talking to each other and telling each other what strikes us as important about a case and what strikes us as the key points that suggest one answer or another.
That's interesting. This will be my last question, and then we'll take a few questions from the audience. But I'm interested, Justice Kagan, obviously there's a lot of political differences on the court, but it also does seem like you get along and that there's a high degree of civility and even some very meaningful friendships that cross significant difference. I'm wondering if there's anything institutional that you do to help create and preserve that. First, I guess I'm wondering, is that right? And if it is,
I think it is right. It strikes me. It struck me when I got on the court as rather remarkable, really, because we do sometimes disagree, and we disagree on some extremely important things on which we feel very deeply. But we do manage. I think the court. For some years, way before I got on and now, has managed to really, the members appreciate each other. I think everybody believes that everybody else on the court operates in good faith, that although we disagree, we're not, that what other people are doing is not illegitimate in any way, shape, or form, that it may reflect a different approach to law and to legal decision-making, but that everybody is operating in good faith, everybody is coming in prepared, everybody really wants to get to the right answer. And so I think that pretty much always folks have a lot of respect for their colleagues and for their colleagues' decision-making process. So, what accounts for that? It's not necessary. There have been times in the court's history where there have been pathological relationships. There have been times in the court's history where some members literally could not stand to talk with each other. And we don't have that. So I think some of it is a little bit of luck. I think some of it is some institutional arrangements that have developed over the years. We do, as I said, we have lunch with each other. Every day we have arguments, and every day we have conference. At those lunches, the rule is that we can't talk about cases. So we talk about people's families, we talk about sports and movies and books, and we sort of make contact with each other as human beings, rather than as judges who have to decide these sometimes fraught issues. I think part of it is that the Chief Justice takes that aspect of the court's functioning extremely seriously and sets a tone. So, this is something that comes down from the top. But I think it's a pretty precious commodity. And I think everybody thinks that. So people work hard to maintain it.
That's great. If you have a question, I think there's a couple of standing mics, so make your way up to one of those mics if you'd like to ask a question, and we'll have time for a few. Yes.
Do you have any advice for young debaters?
You're an interloper.
Yes. The law students get younger and younger.
You know, I do not have any advice for young debaters because I never did debate. But I will tell you that a lot of my clerks have done debate. So I think you're well on your way to a very accomplished legal career.
Let's take a question from this side.
Yeah, thank you so much, Dean Mnookin, and thank you as well, Justice Kagan. My name is Layla. I'm a 3L at the law school. I'm also a student of the Critical Race Studies program. It's actually been my favorite part of my law school experience. So my question is to do with the relationship between race and the law. So critical race theory critiques the law, which presumes itself as a site of neutrality and a site of colorblindness. And rather, CRT maintains that the law constructs and informs race, and that race constructs and informs the law, and that the law itself is a site of racial power. So I'm wondering if I could get what your opinion is on the relationship between the law and colorblindness, and also your opinion on the law as a site of racial power. Thank you.
You know, I'm going to disappoint you in my response, because I kind of don't think that my job anymore. I think academics should think of in those terms about such issues. But as a judge, I was actually talking about this to the class this morning. I think that there are judges who see their role as kind of top-down. They think in very abstract terms, and they're able to answer questions like that because they think in these very general terms, and then they figure out how to plug that into specific cases. I tend to think the opposite way around. You give me a case, I want to think about the case. I want to think about what's going on between the parties. I want to think about the particular legal issues that it presents. And then, of course, I'll understand that that implicates more general theoretical constructs, whether it's about race or whether it's about anything else. But I find that it is more helpful for me to focus on particulars when I judge than to focus on big, general, abstract questions like that. So that's sort of general kind of why I'm uncomfortable thinking in those sorts of terms. You know, obviously, a lot of the cases that the court decides in all manner of areas implicate racial issues. That would be surprising. Race it would be surprising if that were not so. Race is this country's most historic and you know, the thing that is the intractable difficulty in American life, and historically that's been so, and we would be fools to think that it doesn't continue to be. So we have cases all the time. You know, it might be the obvious things, but not only the obvious things, which raise issues of race relations before us. And one should try to be aware of that, to see those issues even when they're not staring you in the face, to understand the different impacts of different sorts of decisions on different racial groups and on race relations. So you know, the court has had some of its best moments and some of its worst moments in dealing with race relations in its history. And so you know, one of the critical functions of you know, challenges of being a judge is to get those answers right.
Thank you. We'll go to this side.
Thank you so much for being here with us, Justice Kagan. I wanted to say first that I think I benefited especially from your advice to both first-year and third-year law students, since as an LLM, I'm technically both. So The first time I ever heard about you was thanks to Jon Stewart when he was on The Daily Show. And
Really?
Yeah.
Now you're telling me something new.
Have you never seen his segment on you?
I don't think so.
Well, he said your name in a funny way, and he talked about some of the funny things going on.
How did he say my name?
You're going to have to watch the clip. I don't think that I can repeat it. But thanks to one of his successors, John Oliver, a lot of the legal issues about the criminal justice system have been regularly talked about by satirists on TV. And I wanted to know.
Have you ever seen the one where we're all replaced by dogs?
Well, then let me first ask
I
you.
think that was a John Oliver one. It's worth watching.
Yeah. He's done it multiple times, I think.
I'm sorry?
He's done it multiple times, I
Oh,
think.
really? Oh, I
Yeah.
didn't know that. I would say it's worth watching once.
Yeah. I wanted to know what your thoughts are on the discussion of legal issues on television through the guise of satire.
Gosh, that suggests such a greater familiarity with Jon Stewart, as I've already just admitted, and John Oliver and everybody else than I have. So, and let me tell you, I watch a lot more TV than most of my colleagues do. So, of all of us, you might be asking the right person, but I don't know. What do you think?
Well, sorry, I don't want to take up too much.
Okay.
Let's go to this side.
Hello, my name is Avi. I'm a 2L, and thank you so much for visiting the best law school in the country.
Okay, wow.
Which is
We got
also,
some chauvinism going
Yeah.
here.
We
Do,
Yeah.
you bet.
which is also a breeding ground for great, excellent law clerks too. So, just putting it out there. Looking back in hindsight on your term thus far, is there a moment, a conversation, or an opinion that you regretted or that you feel like you would want to redo? And if so, what are the steps that you're taking now to sort of prevent that from occurring in the future?
These questions are so hard. Yeah.
Sorry.
Because this is this terrible no-win question where if you admit error, then it's like, she
true.
was wrong. This
and
if
one's
you
no
don't admit error, it looks like, what's the matter with this person? She can't ever admit error. I will tell you something. If I did have an answer to that question, I would not announce it here.
I think you just turned a no-win into a win. That was good. So,
Justice Kagan,
That's it. That's all you're getting.
hi. It's truly an honor to get to ask you a question. Thank you so much for being here. So, recently the law school had a screening of RBG, which is the documentary film on the life of Justice Ginsburg. And Justice Ginsburg in the film was asked what the proper number of women would be on the court, and she responded with 9, saying that it has been... adding that the court has had 9 men on it for many long periods of time, and that has worked well. I just thought maybe you could, or not so well, depending, on your opinion. But
Yes, I thought that her point was a little bit the opposite, but maybe I'm wrong. I wouldn't speak for her.
fair enough. So given that the decisions of the Supreme Court affect the lives of all of the citizens of the United States, can you just talk about the significance of the court reflecting the diversity that this country has?
Yeah. So I actually, there are 2 ways to think about this diversity issue. And in my view, it's the diversity is more significant for one thing than for another. I think often it's thought you put women on the court or you put whatever other on the court and you're going to get a different kind of decision making. And I tend to think that that's not right. I think that you can find women of all kinds of views. It happens to be the case that the 3 women now on the court share a certain number of perspectives about about some issues, but there are plenty of women who don't share any of those views. And I think that the same would be true of any other demographic characteristic that you can think of, pretty much. I mean, I think that there are very occasional issues where kind of any woman, to use the phrase like gets it in a way. So the issue I'm thinking about was actually, I have to go back a long way for this. I have to go back to a case that happened when I was SG, because I couldn't give you a case in the last 8 years that had this flavor to it. But there was a case that when I was SG and I was watching the argument, and it was a case about a 13-year-old girl being strip searched by school officials, and it was actually a kind of terrible argument, because it just seemed like people were not getting what this experience felt like, and were making jokes, and it was kind of awful. And Justice Ginsburg, who was at that time the only woman on the court, was the year before Justice Sotomayor got on, made clear that some of these comments were ridiculous. I mean, not just out of bounds, they were sort of ridiculous. And you could see this just divide between the way a woman was able to sort of put herself in the shoes of a 13-year-old girl being strip searched by a male principal, and the way other people did. Although you wouldn't think it was so hard, but somehow it ended up sort of feeling that way when you watched the argument. Now, I will say, I think it was just like a bad hour for the court, because when the decision came out pretty lopsidedly for the girl. So it wasn't as though the court couldn't think through that issue. It was that, for whatever reason, there was an hour where the woman on the court was thinking differently or speaking differently about the problem than the men on the court were. But as I say, yeah, I have to go back a long time to find something like that. And in general, I think that being a woman does not much affect the kind of decision-making I do, or even the way I speak or think about certain issues. But that is not to say I don't think these diversity considerations are important for the court. I think they're extremely important. And I think they're important because this is an institution of governance, and even though it's one that is at its furthest remove from the populace, and even though it's one where sort of the point of the whole thing is not to be directly connected to the people, still, for the people to have confidence in an institution, you have to have some sense that the institution reflects America, reflects the country you know, that somebody in that institution is familiar with the circumstances of your own life. And I think it's also an institution that people look up to so when I look out at our courtroom has a lot of school groups coming in, and they come in, and I look at these elementary school students and high school students, and Justice Sotomayor and Justice Ginsburg and I, we sit in different places on the bench. Justice Sotomayor and I are sort of on two different ends, and Justice Ginsburg is more on the middle, and there's these women's voices coming from all over the bench, and none of us are shrinking violets. We're all very active in oral argument, and I think this is a really great thing, that all these kids who are out there watching this institution of government work see that women are just like a big part of it, and good for the girls, but also good for the boys. That this is that's what kids should see, and that's what the population generally should see, and that goes for other demographic considerations too. So much as I don't actually have this sort of I think it's just a too reductionist a view to think, well, women judge differently than men, or think differently, or will come out differently with respect to some set of issues. I do think it's a quite important feature of the court now that it has at least 3, and, you know, I don't know, are we going for 9? Is that what we're doing?
So we are very close to out of time. I think we'll have one very final and quick question.
There's
from
a lot
this
of
side.
pressure on this, you
Yes,
know, to
so-
be the last questioner.
Oh, I'm not sure about that. Thank you so much for being here. I just want to echo the deep gratitude for taking time to answer our questions. I'm really, really curious to hear your thoughts on the Supreme Court nomination process, and was wondering if you would be willing to speak both on your experience going through the confirmation hearing just a few years ago, and also...
I think given I'm so sorry, but I think given the events of today, that's the one question I'm not going to answer. I mean, it just, we're right in the middle of events that are swirling around, and I just want to leave it at that and make no news with respect to anything I say.
So,
Thank you so much for your time.
do you have a quick one, or should we end on that? Do you have a quick
Oh, let's
question?
not end on
okay,
that.
all right. Okay, well then I guess we come back to this side. Sorry, we're
I
doing
have a
them
fairly
back
quick
and forth.
question.
Right.
Good evening, Justice Kagan. It's a great pleasure to have you here. When I started to practice in 1970, the court was accepting and hearing argument in well over 100 cases a term. And in recent years, the number has dropped to well below half of that. Would you comment on why you think that reduction has occurred, and what, if any, do you see as the impact of that reduction?
Yeah, the truth of the matter is, I don't think any of us knows. But it's a real phenomenon. I'm not contesting that at all. When I clerked, which was in the 1987 term, we had 140 cases. So I often do this thing with my clerks. You know, it's this one of these sort of, when I was a young person, I went 25 miles barefoot to school. So the Supreme Court equivalent of that is, when I was a young person, we had 140 cases, which is twice what we have now. So if you think you're working hard, you don't know what hard work is. And I think that most of us would like to increase the number. I mean, I think most people think 140 was too much, but that we have capacity to do more than we're doing. But we do have a pretty set set of criteria for what cases we take. Mostly, we look for divisions among the different circuit courts in order to make sure that federal law is being applied uniformly. And in addition to that, we take whatever cases seem of exceptional importance or have certain characteristics where we think really the only people who should be doing this or deciding this in the end is the Supreme Court. So for example, the classic example of that is where a court strikes down an act of Congress as unconstitutional. And we think, you know what, that's part of the judicial role, but if we're going to be striking down acts of Congress as unconstitutional, at least it has to come to us for us to do it. So we have this set of criteria, and in point of fact, I think most of us have the experience, or all of us do, that when we use that set of criteria, we are just coming up with fewer cases than they used to come up with. And I have no idea why that's so. I mean, people have talked about, one theory is that actually the effect of technology means that courts understand what other courts are doing better, and so fewer splits develop in the circuit courts. There's another theory which has something to do with less big pieces of legislation being passed, that a lot of the court's docket relates to diverse interpretations of complicated litigation, so that, for example, in the 60s and 70s, when you had a ton of really important, really complicated new laws being passed in the civil rights area, in the environmental area, and so forth, there was a lot of court business that just sort of followed necessarily on that. And because Congress has been less active in recent years, that's why the court has seen fewer cases. There's another theory, which is a little bit of a crazy one, but seems to be suggested by some of the evidence, because what's interesting about the decline, is that it's not gradual. It just like in a few years, it just fell off a cliff, our docket. And when people have looked at what happened in those few years, the most obvious thing that they've come up with is the retirement of Justice White. And the theory is that Justice White used to vote to grant cert on pretty much everything. And so you didn't really need 4 votes to grant cert because Justice White was always going to be there. You only needed 3. So, in truth, I don't know. I think all of us think we have a somewhat greater capacity than we do, than we are exercising. But I think if we wanted to take more cases, I think it would mean that we would have to change our criteria of selection some. In other words, we would have to expand it. And we would, if we really said, our goal is 100 cases, the way we would do that is we would start doing error correction. Because the Supreme Court has never been understood as an error correction court. It's not as though we just pick cases. Our docket is completely discretionary. One thing a court like that might do is to say we just look around the world, and when we see errors, we'll take the case and we'll correct it. But that's never been the Supreme Court's, or at least it hasn't been for ages and ages, the Supreme Court's understanding of its role. The general view has been that appellate courts, circuit courts are to do error correction, and that that's enough of a check on the system, and that the Supreme Court ought to focus on either these massively important cases or play the systemic role that circuit courts can't play, because it really is sort of policing how circuit courts relate to each other in their interpretation of law. But I think this problem could be solved if we just sort of said, well, we're going to just take cases when we see errors. But that would make it a very different kind of institution.
Thank you.
We just heard, this is the end of Justice Kagan's summer vacation, such as it is. The term begins Monday, and she'd be open to working even harder. So on that note, thank you so much for being with us. We really appreciate it.
Thanks a lot.